This presentation is made for the buyer who wished to acquire company in liquidation to be sold as going concern basis under the provision of Insolvency and Bankruptcy Code of India. This presentation is divided into 5 parts. Understanding the concept of going concern sale, source of information about such sale, process of acquisition, terms and conditions of sale, and plan for acquisition. Out of the above, terms and conditions and acquisition plan concession and relief needs special attention. Let's start. Let's understand the concept of sale of a company in liquidation on going concern basis. The liquidator realize the assets of the company in liquidation through sale. The realization of assets by sale of company as a going concern is one of the mode prescribed under liquidation regulation of IBC. There are 2 types of such sale. 1. Sale of the company as a whole on going concern basis. In this type of sale, company continue with buyer. And 2. Sale of the business of the company as a whole on going concern basis. In this type of sale, business goes to the buyer and company get dissolved. Going concern means all the assets, tangibles or intangibles and resources needed to continue to operate independently a business activity which may be whole or a part of the business of the company without values being assigned to the individual asset or resource. Mandate to sale as going concern basis given by the Committee of Creditors. In absence of such mandate, it is decided by the liquidator of the company. Assets to be included in the sale is decided by the Committee of Creditors. In absence of such mandate, it is decided by the Consultation Committee of the company. Going concern sale done through e-auction based on reserve price. Reserve price is realizable value of all assets included in the sale. The entire sale process should be completed within 90 days from date of liquidation. Let's know about the source for information about companies in liquidation on sale. Insolvency and Bankruptcy Board of India website displays the list of the companies in auction under IBC. Auction notice is also available for respective companies. The auction notice contains information about auction such as date of auctions, brief description about sale, details of liquidator and auction platform. The auction platform are selected by the liquidator for e-auction of the companies in liquidation. There are various auction platforms through which the e-auction are done by the liquidators. Some of these are Right to Vote, Auction Tiger, e-auction, bank auctions, NESL, etc. One can get the listing of such on these sites too. One can find the link of auction platform through Google. On the auction platform one can find auction notice, details for auctions, auction process documents, photograph, etc. Their details are uploaded by the liquidator of respective company. Some of the recent sale transactions and upcoming auctions are listed below in the table. In recent sale transactions, it was noticed that there are only 2 or 3 bidders who have participated in the auction. Final price were also closed to reserve price. Bird's eye view of the process of acquisition of the company in liquidation is explained in this section of the presentation. For the purpose of understanding the process of acquisition of the company to be sold as going concern basis is divided into 5 steps. 1. Submission of expression of interest in response to auction notice. 2. Declaration of qualified bidders by the liquidator. 3. Due diligence of financial and operational state of the company by the qualified bidder. 4. Participation in e-auction conducted by the liquidator. 5. To become successful bidder, payment of bid amount, and completion of sale. During the process, the bidder will come across 2 following important documents. Auction notice. This is the first important document which contains auction details such as company name, what is going to be auctioned, reserve price, timeline for sale process, contact details of the liquidator and a reference to get process documents and other information. Process documents. This is the second most important documents issued by the liquidator. It is available on the auction site. It is also available on request to the liquidator. It contained detailed description of the auction process and terms and condition of the auction. Expression of interest. The template for expression of interest is part of the process documents. It includes format for bidding, confidential undertaking, Know your client, format of the bidder, eligibility criteria, format, etc. Draft letter of intent. It is generally not included in the process documents. However, liquidator may share it on request of the qualified bidder. Sales certificate and NCLT order. It is the closing documents for confirmation of sale. Let's understand the important terms and conditions of the sale. Disclaimer in the process documents. The bidder should carefully examine the disclaimer in the process document. The liquidator generally disclaim the authenticity, accuracy, correctness or completeness of any statements, facts, information or opinions in the process document. Liquidators have taken the stand that process documents are not a legal document. The bidder should satisfy that he is eligible for bidding and not disqualified under Section 29A of IBC. Sales terms. It will be expressly written that going concern sale is generally as is where is basis, as is what is basis, whatever there is basis and no recourse basis. Bidder should examine whether going concern sale is for company as a whole or only for certain business of the company. The bidder should find out what are the assets not included in the sale. Reserve price. The bidder should examine history of revisions in the reserve price. The bidder should also see whether any amount payable over and above the reserve price. Earnest money deposit. Earnest money deposit is payable once bidder is qualified for auction by the liquidator. Earnest money deposit is generally 10% of the reserve price. It is payable through bank demand draft or bank guarantee by the qualified bidder. It is refundable to all unsuccessful bidder. It will be an interest-free deposit. Due diligence. The liquidator generally do not accept any responsibility or liability in respect the accuracy, correctness, completeness or reliability of information provided in the data room. Therefore, it is most important to do robust due diligence relating to operation, legal and financial information on the company. Consequently, it is most important to examine number of days available to complete the proper due diligence from bidder perspective. Closure of transactions. The liquidator will issue letter of intent for sale to the successful bidder after the end of the e-auction process. This document do not contain any relief or concession available under IBC. The bidder should carefully examine the disclaimer put by the liquidators. At this point of time, the bidder should give a list of concession and relief needed to the liquidator. The bidder should direct the liquidator to get such relief and concession approved in the order of NCLT. It is important to note that the such sale is subject to approval of NCLT and liquidator is not liable in case NCLT reject the sale. Let's understand the acquisition plan, concession and relief. The successful bidder is required to deposit the bid amount in the liquidator's account of the company. Thereafter, liquidator will issue the sale certificate to the bidder. In accordance with provision of IBC, the liquidator will pay the liquidation expenses and creditors to the extent it is available. The bidder needs to give direction to the liquidator as how he need to structure the transfer of ownership of the company, and the list of concession and relief needs to be availed from NCLT in its order for sale. Significant directions needs to be given to the liquidator for approval from NCLT are as follows. Transfer of ownership of the company. All type of existing shares of the company along with rights and liabilities shall be extinguished. The liquidator shall issue fully paid up fresh equity share to the successful bidder for the bid amount given by him. Change in the management. To replace all existing directors with directors of the bidder and make bidder as authorized signatories for all statutory and bank purpose from the effective date. Status of the company from in liquidation to active. These changes needs to be done in MCA portal and in the portal of all statutory authorities. Section 32A of IBC gives immunity against past offense of the company to the company under new management. In the recent past, NCLT has recognized the principle of transfer of ownership on clean slate basis. It means specific reliefs and concessions against past burden and offenses. Example of relief and concession are as follows. 1. To write back all outstanding dues of unpaid creditors. Government dues such as income tax, GST, VAT, TCS, custom and excise duties, VAT etc. 2. 2. Release all types of existing rights charges lien of the creditors on the existing and future assets of the company. 3. All claims or demands of any person including demands of statutory authorities, government dues, any type of guarantee given by the company and cases filed against the company shall stand permanently extinguished or dismiss. 4. A direction to be issued that the all inquiries, attachments, investigations, assessments, notices, non-compliance of laws, to any period before effective date or arising on account of the acquisition shall be deemed to be withdrawn or dismissed. In order to make the transfer smoothly, the bidder needs to ask for specific direction from NCLT to order the liquidator that from effective date 1. To write back all unpaid liabilities as on effective date and get extinguished all liabilities arising out of non-compliances of any law, regulation or notification prior to effective date. 2. To do necessary formality and filing with MCA and other concerned authorities in respect of removal of all encumbrances, charges, attachment and lien on company's assets. 3. Preparation of financial statements. To take all steps required to make accounting entries for the smooth transmission and clearing all balance sheet before effective date. 4. Compliances up to effective date. To do all the compliances for the period up to effective date including filing of returns with MCA, income tax and GST authorities etc. 5. To pay all liabilities arising after liquidation and before effective date from the bid amount.
Thank you for your valuable time. Please give us your feedback on the comment section. If you need this type of presentation on company under insolvency or liquidation, do write to us. Your comments and suggestions are valuable to us. Thank you again.